Hi, I'm Connie Kaplan. I'm an immigration attorney. We help people make the United States their permanent home. I'm going to focus today on Florida law as it relates to immigration considerations during the divorce. We'll touch on divorce. And because we are in Florida, I'm going to try to limit my comments to Florida law, even though immigration is federal. So I'm going to start first with the statement that a divorce and annulment are exactly the same for immigration purposes. An argument could be made that an annulment is void ab initio and then from the beginning, and then you cannot proceed with that application, but that argument has not been made in years, and it really is treated about the same way. We don't have legal separation in Florida. Other states do. We have people who have obtained separations in other states and they move here, or in other countries and they move here, and immigration law will look at the state or country law at the place where the separation was entered into to determine whether parties are really divorced or they are really separated or whatever their marital status is. But for argument's sake, let's pretend we're talking about Florida and divorce. I need to go into a little bit of lingo and just give you two different terms so you understand them. It's a difference between visa and status. A visa is a foreign national wanting to come to the United States, going to the consulate or the embassy and asking for permission to come to the border and knock on the door and say, would you please let me into the United States for either a period of time, short period of time, or a permanent period. The minute they get that permission, that only allows them to come to the border, knock on the door and say, please let me in. It is up to the Customs and Border Protection officer or the immigration officer at the port of entry to either allow them or not allow them. And I hate to say it, but it is discretionary. Just because you have a visa doesn't mean you're coming in. So if the immigration officer doesn't like your face that day, you're not coming in, regardless of how eligible you could be. Everything about immigration is discretionary. Everything. You could meet all the criteria, A, B, C, D, E, whatever it is, and then they have officer's discretion. You could meet all the criteria, you could be 100% eligible, and they could still deny it because the officer has reason to believe you will not fit in.
Is there a definition for that?
Reason to believe?
No, not fit in.
Not fit in?
Yeah.
It's up to interpretation.
Okay.
It's called discrimination.
Wow.
Right?
Oh yeah, but we don't call it that. It's reason to believe.
So you gotta bribe those guys, right?
So you have to
That's how you
impress
bring
them.
cash.
Yeah. Impress them with cash. Yeah.
So, yes, you cannot do that. So,
You are being videoed.
yes, I know, but that's the way it is, and I'm not lying about it, so there it is.
Officer of the court.
Then there is a big difference in divorce. When you're getting divorced, it makes a big difference in what your status was before you got married, what your status is at the time you file for divorce, and what the status will be after. And it really varies. I can't give you a whole flow chart of how it's going to be because there are a million variations. So I'm going to stick to the basics. I gave you a handout, and one of them, the first one, example one, if we're going to read it out loud, talks about temporary visas. If people have been here on student visas, work visas, they tend to be here for quite a few years, they get married, they get divorced. Unless you actually ask them when they come for a divorce consultation, you wouldn't really know what their immigration status is. So let's go with the first example. For example, Olga is a Russian national in the United States on an F1 student visa. She is married to Ivan, who's also Russian, and he's on an F2 as Olga's spouse. He gets it based on his relationship to the spouse. They have a 6-year-old Natasha, who's also Russian, not born here. They decide to file for divorce. What happens to Ivan? What happens to Natasha?
Ivan's deported, Natasha goes into a cage.
Nope. No, it doesn't work like that. So, because they're on a temporary visa, Ivan's status in the United States terminates the minute the divorce is final. He literally starts the minute the divorce is final, say it's August 8th, the minute the divorce is done, beginning tomorrow, he starts accumulating unlawful presence. He needs to leave the country right away. Natasha, because she stays with her mother, Natasha gets to stay in the United States.
Does it make a difference whether Natasha was actually born here?
If Natasha's born here, she's already a U.S. citizen.
So
So she's like anybody else at
anybody
home.
else.
Yes. So we are assuming she's not, but, all right? Natasha can still attend school as long as Olga continues to go to school. Olga can violate her student status just by not going to school, not attending classes. So if Olga wants to really screw her family over, and I hear this more often than you would believe, all she has to do is stop attending school, she violates her status, and they're all, out of status, for lack of a better word. Neither Natasha nor Ivan can work. They don't get the work permit. They are not allowed, so pretty much whatever schooling she's paying for at school, whatever tuition money she spends, she also has to spend money on supporting her entire family because neither one of them can work or apply for a social security number or anything else.
What happens when Olga graduates?
Olga graduates, then assuming, it doesn't matter at that point whether she's still married or not, she's the primary holder of the visa. She can go into optional practical training, and then she's hoping that she gets an employer who's going to sponsor her, or she has to return back to her country. Next example, we have Raji, who's in the US working for Microsoft on an H-1B visa, which is an employment-based visa. It's temporary in nature, lasts about 6 to 7 years. His wife, Anika, has H-4 derivative status, very similar to what Ivan has, it's just a different letter, as Rajit's spouse, and she's eligible for employment. As of right now, a spouse of a worker who's on an H-1B is eligible to apply for an employment authorization and can work for any employer in the United States. That is about to change. There is a bill that was introduced in Congress to change that, and we are also expecting an executive order to change that as well. So if they get divorced, considering the current situation as it is today, where she's allowed to work, what happens to their immigration status? So let's think about this for a second. Rajit doesn't matter. He's still employed. His status here, based on his employment, has nothing to do with their marriage. He's fine. The minute they get divorced, Anika immediately falls out of status. And unless she changes it to a status that is independent to Rajit's, for example, she goes to school by herself, for example, a student status, or she leaves the United States, comes back with a tourist visa, or she finds an employer willing to sponsor her, she is out of luck. If the reason for the divorce, however, is Rajit's abuse of her, okay, she might be eligible for a U visa. But she'll have to testify against Rajit, and he will, in criminal court. How about if Rajit has a domestic violence charge and he's on a temporary visa? He's on the work visa. He doesn't even get to be deported. He'll be on the first plane so fast, it's not even funny. So, immigration doesn't look kindly at all on domestic violence. Any immigrant who is charged with domestic violence, we're not even talking conviction at that point, it's subject to deportation. They do need a conviction or an admission to actually deport you, but again, we have the reason to believe. So, yes. Domestic violence is one of those things that immigration does not look kindly upon, and unfortunately, people know that, and there are people who make false allegations all the time. Yes, Quentin?
I just had a quick question with Rajit.
Yes.
Let's say they had a child that was born in the United States or was not born in the United States. If Annika divorces Rajit, let's say their child is born outside the United States, what happens to the child then?
Well, the child also has derivative status, so the child can attend school while they are here, but if she gets deported, then it's, let's talk about it. They get divorced. What happens? What's the rule for child custody? What's the rule for child support? It's always best interest of the child. So at that point, the court will have to look at the immigration status and determine what would happen if the mother gets deported, what would happen if the mother doesn't get deported but is stuck here out of status with no work permit, no ability to work, no ability to support the child or pay child support.
Wouldn't you have to seek a reload?
But there's no way for Annika to use the fact that she's a parent of a minor child currently legally in the States?
No, none whatsoever. None whatsoever. The child, if it's a U.S. citizen child, can sponsor the parent only when the child becomes 21. Until then, it doesn't even matter for qualifying relative for any waiver whatsoever. And in her case, being that she's a derivative on an employment visa, she doesn't even have that option.
Can I ask a question? I was watching one of my favorite series last night, and there was a skit that the parents were illegal for 18 years, one of the daughters is a citizen, the other is not. They are deporting the parents, and a daughter that's not a citizen could be adopted by foster parents. Is that like I know it's a TV show, but I was just asking a question.
It depends on the age of the child. If the child is under
Teenager.
what's a teenager? An 18-year-old is a teenager.
Well, that 15, 16-year-old.
15, 16, as long as it's it's
So
a
then
legal
the parents
adoption.
could be deported, and the child could opt to stay
Well,
here.
Correct.
The older sister who was a citizen could probably do it. Right?
No,
Could a sister could adopt
Yeah.
another sister?
depends on the age of the depends on her age because adoption
Next is 18, right?
well the older one. How old is the older one?
I like 17. Like they're just
Oh,
okay.
they're
They're both-
under 18.
Yeah. Family member adoption is always an option, but if the adoption happens after the child is 18, does not confer upon the child any immigration status whatsoever. It would have to happen and be finalized before the child turns 18.
Because when she's 18 and she's still not a citizen or registered or green card, she would then be deported by her parents.
Correct, and most likely will be alongside with her parents. It's also issues with, there are also issues with the Hague Convention on the adoptions, because if the country that where the kids were born is part of the Hague, then the adoption has to follow certain processes, and that takes about 2 years. So if the processes are not followed, immigration will not recognize the adoption. So, okay? So the same thing happens if instead of Rajit being on H-1B visa, they are on investment visa. Say you have an investor here from Turkey or wherever they are from, and they open the business, husband and wife, but the business is under the husband's name. The wife has a work permit, similar situation. The minute they get divorced, the spouse who's dependent on the other one for the visa loses status. So they have to come up with a different option of staying here independent of the spouse, or they really have to leave. Most people don't leave, and that's where we have people who overstay their visas, or they stay here unlawfully, because people who have children especially will not leave their children here. They don't care about their own status. They'll just stay and be with their kids no matter what. The most common family process, however, and that's the next example, that's example 3, and I'll go over that a little bit more into detail, is Jake. Jake is a U.S. citizen. He marries Maria, who's from Venezuela, who overstayed her visa and is now pregnant with their child. Jake files a petition on behalf of Maria, and concurrently Maria files an application for permanent residency. This is the most common process, okay? Once received, the residency allows, upon passage of time, to apply for U.S. citizenship. And this is another misconception that's out there, that people can just come and apply for citizenship. It doesn't quite work like that. Until you have been a permanent resident and time passed, either 3 years, 5 years, depending on your case, you can apply for naturalization as a U.S. citizen. There is no application or form that you can fill out and say, no, I want to be a U.S. citizen. It doesn't work like that. So little Laura is born, and sometime later the couple decides to file for divorce. I made it specifically vague in the hypothetical, saying sometime later, because this is where the timeline is really important, and we need to think about what was Maria's status at the time they entered into the marriage. What is her current status? When do they intend to file for divorce? Did they file already for divorce? Is the divorce already final? How much time did it pass? Okay, so exactly where they are in the application process. So let's say they got married, Maria's still pregnant, they didn't have little Laura yet. Jake filed a petition for them, and then they're having a fight while she's still pregnant. They intend to file for divorce. The minute they file for divorce and the application is pending, the application is literally abandoned. You just have to send them a letter, say I'm withdrawing my application, and Maria doesn't get any status in the United States. Assuming that the divorce is final. If they just intend to file for divorce, it doesn't matter, because an intent to file is nothing, it's just intent. You can change your mind, you can have reconciliation, you can go back and forth a few times. If you're very young, you're gonna do that quite a few times. And I hear it, I see it. So these people break up and come back together over a period of 2 years, maybe 10 times. So I had one like that. So Nothing happens until they actually do file for a divorce. The minute they file for a divorce, it's a matter of public record. It's already there. Even if the status, if they do file for divorce, Maria's status reverts back to whatever she had before. So remember when we said in the what would be her status before? A temporary visa, like a work permit, like a work visa, or student visa, or temporary protected status example, for example, people from Haiti who came here after the earthquake, or people from El Salvador who have been here for a long time, they're in a temporary protected status. They would revert back to most of the statuses, unless that status was a non-immigrant visa, in which case, the minute they got married and they filed a petition to become an immigrant as a permanent resident, they exhibited what's called immigrant intent, and you can't have both, so in that case, you're out of luck.
Can I ask you a
Yep.
question?
Sure.
Because I've been seeing this a lot lately.
Mhm.
I always thought that if you came here to the country and you married a U.S. citizen, that you were then, because I know they did all those, people would get, can you marry me just because? I actually already done that. Now I'm seeing though, like, there was a woman recently, been here for whatever years, married to a U.S. citizen, has 3 kids, blah, 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 stand-up citizen, and they just deported her. What do you have to do? I mean, so it's just not getting married, right? I mean, it's...
Getting married and marriage by itself does not grant an immigration
Why do
status.
these people not, once they get married, go through that process so that that doesn't happen to them?
They might be able to, they might not be able to. So, say Maria crosses the border from Mexico and finds Jose in Texas. They get married and they have 3 kids and whatever, okay? If Jose is not a U.S. citizen, okay, Maria can't get status. Let's say Jose is a U.S. citizen. Maria crossed the border. Maria can't simply apply for a green card. She would actually have to have Jose apply for her, a petition for her. Then she would have to travel back to her own country, wherever she's from. She might not be from Mexico, and be processed there. The problem is, by that time, she has been here unlawfully for a period of time, and she'll be prevented from coming back. So they'll be in limbo. Or they'll be stuck abroad for a set period of time, depending on how long they were here unlawfully. If they were here, say, under 30 days, they could probably come back, no problem. If they were here under 180 days or over a year, they could be barred for 10 years. And if they try to cross the border twice, then it's a permanent bar. You're not coming back.
What if Jose, U.S. citizen, vacationing in Mexico, meets Maria,
Yep.
marries her in Mexico, wants to bring her to the States? What's that process?
Are they married or are they not
They're
married?
legally married, but they're not legally married in the United States. They need to, validate here, but they're
He
legally
needs to
married.
petition for her. She'll be stuck there for about 2.5 years until the process takes place, and then she'll come over here.
Wow. Unless she's,
Assuming she doesn't have a criminal record, assuming she doesn't have a previous immigration bar because she tried to cross the border and was sent right back. There are other options, but
unless she gets a visa in another manner, other than by.
she cannot obtain a visa that's not based on her marriage because she would have to show non-immigrant intent. And how
Okay.
are you going to show
Got it.
non-immigrant
Got it.
intent when you
Got
want to
it.
be with your husband?
Got it.
What if someone is a U.S. citizen but then gets rid of their citizenship?
Meaning?
So they're a U.S. citizen, or they have dual citizenship, let's say, between the United States and the United Kingdom.
Uh-huh.
And then they say, okay, for tax purposes, because I have a client that did this, for tax purposes, they want to just be in the UK.
Okay.
So now, are they immediately like,
If they are no longer a U.S. citizen, they are no longer a U.S. citizen. They theoretically don't have a permanent residency. They can apply for permanent residency again as if they never had it before. Immigration does not look kindly upon abandonment of permanent residency or abandonment of citizenship. So it would be an uphill battle, but it's doable. Okay?
I've heard if you're here from another country legally and you marry a gringo, and
You know they're recording this, right?
and I've heard and I've seen a couple cases where 5 years is typically the rule of thumb that the person has to be married for them to become a citizen. Is that correct?
Correct.
Okay. And they have
However,
to
you-
document, and they have to take
Absolutely
pictures, and
everything.
there's a whole process on this 5-year timeline. They have to-
Yes, it is, but if it's based on marriage, they could apply as early as 2 years and 9 months, but it really depends on how long the US citizen has been a citizen, if they live together, if they're married, whatever. It's a lot.
And we have to go into.
During holidays, you have to take pictures and keep a book, and it's a pretty
People miss-
stringent process.
The burden of proof is much higher than just submitting a couple of photo albums with pictures, because truth be told, if I want to make anything up in a photo album, I can make anything up in a photo album. It's more about joint financial responsibility than pictures.
My first was illegal, and we had to go to interviews constantly, and what is his favorite color, and
Yeah.
they would completely test us.
And if you get it right, you're not married. You're not real.
Right.
So, immigration is not a DIY process, that's what I'm trying to say, okay? So, once a divorce is filed, Jake petitioned for Maria, the petition is pending, she reverts back to her old status. Even if they reconcile, it will be hard to show the immigration officer that it was a good faith marriage. In this case, the fact that she's actually pregnant with their child or already had the child will help, but doesn't always overcome the fact that they entered into a good faith marriage or not. And it's a bigger issue, and it happens quite a bit. And in the past 2 years, I heard this story about 4 or 5 times, and I don't believe it anymore to a certain extent. I have guys coming to see me, and they say, my wife told me that the baby was mine, and it turns out it's not, and it's somebody else's name on the birth certificate, and I found out at the hospital when the other guy came to show up and held her hand.
4 or 5 times like that.
I'm not joking.
Same guy?
No.
Oh, welcome to my
Like a
world.
good
Okay,
Yeah.
so I cannot make up these stories,
Yeah.
and it's only so many, you believe it the first time, you believe it the second time, and then you're like,
Wait a minute.
nah, she was probably in a relationship before, you just probably had an agreement with her, and you entered into a fake marriage, and now you're a crying victim, and it's not entirely accurate. So there is more to be, I'm not saying they're not truthful, but I have to take those with a grain of salt after you hear quite a bit. So if I heard that a few times in the past few years, think about how many times the immigration officer heard them.
Yeah.
So you better have this much documentation to overcome the presumption that you're lying, okay? And it happens more often than you think, Angela, I would tell you.
Yes.
So,
Funny story, my boyfriend, my husband now,
Wait a minute, your
Yeah, I was
boyfriend?
gonna say.
Whoa, let's just talk about that.
when he had knee surgery, I went to get him, and his stepmom was there, who had the Anderson last name, and I had a different last name. And it happens, the nurses say all the time at the hospital, where boyfriends, girlfriends, wives, husbands show up, and they have fights and brawls and everything over the same
Yeah.
circumstance. So they have to be very careful about who they let in.
who they allow incorrect.
Yeah.
Well, I have a client that it's a gay guy married to a woman for immigration status, so
Oh my
I
God.
figured that it would have been easy for them to figure that out, right?
Well, except for when you have a marriage, you have a legal father,
What
Not
about
one
right
that
now?
which
they're
may be
older.
different from the biological father.
Does it make a difference now because of the gay marriages are illegal? Like as a gay marriage, can you sponsor your?
Heterosexual marriages are treated the exact same way as same-sex
No,
marriages.
no, I mean a gay guy
And-
married a woman.
No,
And
no,
they're-
not what you said.
And they're
I was
not
wondering
supposed
if,
to
like-
treat those couples any differently than.
But it's still up to discretion.
It is up to discretion. The biggest challenge we have found is the officers not being educated into what it means to be gay, lesbian, transgender, queer, bisexual,
Right.
polyamorous, whatever, because we have a whole, and people do live their life. That's their lifestyle. That doesn't make them unfruitful, doesn't make them any less important than anybody else. And it's a matter of the immigration attorney and the clients to actually educate the officer at the time of the interview. I haven't found it to be an issue, so they get training. They're supposed to get training.
You mentioned filing for divorce. It doesn't matter if the divorce doesn't go through. It's once it's filed.
The divorce goes through. We have Angela as an attorney. We have.
No. What I mean is, a lot of times, petitioner files for divorce. Respondent doesn't even know that the filing is taking place.
Correct.
So let's say, for instance, someone is in a marriage with an immigrant that is depending on the marriage for their citizenship, and they just want to get rid of that spouse.
Okay.
I mean, you usually got to turn both keys to finalize the divorce. But once it's filed, that's enough.
No, the divorce actually has to be final to
Okay,
have an
that was
effect
my
on the
question.
immigration. However, if it's a matter of public record and the petition was filed, and then if the petition is filed, it's obviously irreconcilable, and most of the time. And then the spouse, only one spouse shows up at the interview. That's just a denial right there.
Yeah.
Okay.
Quick question, in Florida we have support unconnected to a dissolution of marriage. How does the immigration regard those cases?
It doesn't matter. It's a civil matter. They don't look at civil matters
I mean,
unless
they're
it's a
not
divorce.
residing as a couple, that's why.
If they're not residing as a couple, then depends on what the application, where the application is in the process. Okay, so in where the application is in the whole process timeline-wise. So let's say Jake filed for Maria, but so far they have not gotten to their first interview, so the application is still pending. Okay,
Right.
so if at that point there is a petition that is filed for divorce or separation or whatever, they're not going to get the green card because they have to live together in a good faith marriage and share the household and financial responsibility and so on. However, if they're filing for that divorce after she already had the green card, the first conditional green card, if you were married for less than 2 years, at the time you had your green card granted to you, you're getting a conditional green card for 2 years. If you are married for 2 years and a day or more, you're getting a permanent green card for 10 years, and at that point, it really doesn't matter what your spouse does or doesn't do, or if you get divorced, you're gonna get to keep your green card. But if you're in the first 2-year period, you still have to show a good faith marriage. And when you file for the removal of those conditions on that 2-year green card, you can file it 2 ways. Either a joint petition with your spouse, for that you have to be married and living with the spouse, so in that case, separation will not help, or you can file as a waiver. Now here's where the kicker is, because you can file for a waiver petition independently of your spouse, but you have to have, at that point, the divorce has to be final, and you have to meet one of the 3 criteria, or all 3 criteria. Either you have to prove that it was a good faith marriage, that you were in an abusive relationship based on the Violence Against Women Act, and that applies to men just as well, or you have to show that you would experience extreme and exceptional hardship if you were to have to return to your country. It gets even more complicated if you have children. There are ways to preserve the green card. The hardest part is if you get divorced or the spouse decides to divorce you before you even get the first green card. After that, there are ways to save it. The fact that you get divorced after you already obtained the green card delays the time that you can apply for naturalization. It doesn't affect much else. Let's think if there is abuse. That makes a difference. Say the U.S. citizen abuses the spouse, the foreign spouse, or the child, you can file for self-petition. The abuser will never know because it would put them at risk. And you can self-petition for a green card on your own based on the abuse. You just have to prove the abuse. When I say abuse, it doesn't have to be physical. It could be mental abuse. There is a power and control wheel for immigrants that people use and the psychologists use when they determine if there is abuse going on, especially if it's mental, that we use a lot, and they need to go to a forensic psychologist. There is more going on. Yes?
So although this is kind of new to me, maybe most of us, do you find that the people that come to maybe the family law lawyers are pretty savvy about what this means to their spouse?
No.
No way.
No, and the main takeaway, and if you really look at them at the bottom of your papers, is find out, you're asking the clients about their immigration status is not something you're doing to them, it's something you're doing for them. Most immigrants will not talk to anybody about their immigration status. It's culturally ingrained in them, don't tell anybody because they're gonna go and tell on you. So they will not talk about it. They need to believe you, they need to trust you, they need to know that you have their best interests at heart before they'll tell you what their immigration status is. But it's critical. You can use it in the negotiations for the marital settlement agreement. You can use the immigration status, not as leverage, because you can't use that over anybody.
Wait, you're not supposed to, but you can.
Well, no, not really. Not really. And also if you make false accusations, I'll go into those in a second. If you make false accusations also, you're criminally liable. So I have seen some divorce attorneys, obviously nobody in this chapter, who try to use it against the immigrant, but the judges really throw them out when there are children involved or when there is abuse involved, and we've seen the sour grapes cases all the time.
I mean, irreconcilable differences allowed for divorce. So,
Irreconcilable differences are allowed in divorce. In some cases, though, adultery, for example, is a bar to immigration benefits. So if your client wants to say not irreconcilable differences and they want to say adultery, the other spouse better fight it if they are a foreign national, because they can never obtain immigration benefits without the waiver based on that. The same thing if the foreign national is accused of the battery. Sometimes a U.S. citizen calls the police, for example, and say, my wife beat me up. Okay? Domestic violence charges prevent you from obtaining immigration status. So it's very important, especially in tension areas like family law, or when they go and see a psychologist, that we know what their status is. It's critical, and we need to know where they are in the process. Maybe spend $100 and go see an immigration attorney for a consultation and figure out how would this affect the case. Sometimes they don't even know what would happen to them if they get divorced. Sometimes they just don't think about it. We need to ask them. Most people come from South America, for example, especially here in the Florida area, and they have what's called, it's a civil law jurisdiction. It's not what we have here, common law jurisdiction. In their mind, attorneys work for the government. You have to express to them the confidentiality of your talks with them. You have to tell them that anything you tell me does not go to the government, does not leave this office. It stays with me. They will not disclose. But you're doing them a disservice if you don't ask them, because it should be a part of your whole strategy with these people, for financial reasons, for real estate reasons, for criminal charges, especially if there are domestic violence involved, if there is abuse involved. Get them to talk. Get them to talk. There were a few things I wanted to, do I still have time?
1 minute.
All right, so there are a few things I want. It's important in calculating alimony and child support. If one spouse can no longer work, because all of a sudden they have no status and they don't have an employment authorization, how is the judge going to order child support from the spouse? It would be akin to saying you have to go and commit a crime and be employed without a permit in order to be able to pay child support. So those are serious considerations. What if the person gets actually deported or they lose status and they have to leave? What happens to time sharing and parental responsibility? How are the kids going to visit, say, Russia or Pakistan or whatever? Okay. What else? 2 more things and I'm done. What if we allege adultery and marriage fraud? Let's talk about marriage fraud. The U.S. citizen could face criminal liability for a false marriage fraud allegation. I get at least once a month a call from a U.S. citizen saying, I want my spouse deported, she just used me for papers. Okay? Well, what do you mean she used you for papers? Well, I brought her from whatever country, and now all of a sudden she has her papers and now she's leaving me. Okay, and how exactly did she use you for papers? Well, I think she just did that. Can you explain to me what do you mean by that? Well, it turns out they have 2 kids together, obviously, it's not just papers. Okay, and I get this once a month. The thing is, they just want full custody of the children and they want the wife deported, and how do I make that happen? And no immigration lawyer will help you do that. So don't send
but
it.
a divorce attorney might.
Divorce attorney might, but they need to know exactly how they are doing it and what they are doing. Okay. If there are allegations of adultery, if there are allegations of fraud, just be careful with them. That's all I'm saying.
Well, we don't care about adultery in divorce law.
We
But
don't.
in immigration, they do.
We don't. But in immigration, we do. And if they come from another state where they can allege adultery and they are coming to see you for modification or for something else, you might have an issue.
And if there really was adultery, then they do hold all the cards, really.
They kind of do.
Yeah.
Because if the foreign national did not fight that,
Or is guilty of it. I mean, that might
or
not be
is guilty
pleasant.
of it. Yeah. Any other questions?
So in terms of, it sounds like pretty much if you're the immigrant and you break pretty much any law, that's gonna screw you up. You've gotta be like the
Law-abiding.
perfect citizen, law-abiding.
Yes, and most of them are.
I mean, it's like
Most of us
DUI,
are.
is that,
DUI, actually, it's against a charge of DUI. For immigration, you do not need a conviction. You can just have a simple admission. If somebody is being put in drug court in Broward, they actually have to make an admission of the crime because they had a joint in their pocket, okay?
Okay.
If it's in Miami, they got a little smarter and they don't request an admission from the person in order to put them in drug court. So it's a big difference in the immigration consequences for that person, whether they were caught in Hallandale Beach or in Aventura.
Wow.
Okay, so, and that's a simple possession. There are many other examples for domestic violence, other PTI programs, other diversionary programs where an admission is sufficient for immigration. They don't need a conviction. So you need to be careful what you say and what you don't say. And most people go with the public defender who doesn't advise them of much. And immigration consequences is not necessarily their thing, and they don't know what they're doing, and that's all they have to do.
Wow.
There are a lot of advantages to marrying a foreign citizen.
I guess so.
What, you
Doesn't
kick them out?
doesn't go well, they get deported.
Yeah, like, you're done.
Those are the good ones.
Yeah.
Just one, Doris, I
You're
promise.
just so good.
Consider the U.S. citizen in this part, because the U.S. citizen is the one who petitions for the foreign national. When they do that, they actually have to sign an affidavit of support that says, if this person is ever going to become a public charge, going on Medicaid, food stamps, or whatever, I am going to provide the equivalent of the poverty guidelines for these people for support. And that does not matter for alimony. So for example, right now, say there are no kids involved, it's $20,575 that they have to provide to their spouse, okay? So whether they get alimony or not, they can enforce that. They can just go to court and enforce the agreement. So while the contract is between the U.S. citizen and the government, saying the government can sue you, sometimes it's best if, for example, Quentin and Angela, they advise their client not to get divorced if they can wait a few more months, just so they can, the foreign national can apply for citizenship, because divorce does not terminate the obligations under the affidavit of support. So if you divorce your Venezuelan wife, okay, and she decides not to apply for citizenship for 30 years, you're on the hook for that agreement for 30 years.
Wow.
Okay? So that's a serious consideration.
So the thing that they're talking about, Stephen Miller was just, pointing out that they're trying to say legal immigrants.
Oh, can we not bring up that name?
I know, he's disgusting.
Please.
But legal immigrants that they're saying now, if they take any welfare or food stamps or anything like that, they can't apply for citizenship. So are you saying that's already the law?
It's not the law yet, but they also say that Obamacare is included into that. Now let's remember,
Yeah.
Obamacare was mandatory.
Mm-hmm.
So how are you going to consider somebody ineligible for an immigration benefit when they did what they were asked to do?
Required.
Required, yeah. All right? Well, thank you guys.
As